Ajụjụ onye ọbụla kpụ n'ọnụ nke ikpeazụ banyere Maazị Nnamdi Kanu bụ Maazị Nnamdi Kanu o nwere ike ikpepụtanwu onwe ya na ọ bụrụ na ndị ọkaiwu anọrọ ya nso. Mara ama na Maazị Nnamdi Kanu gwara ndị ụlọikpe ụnyaahụ na ọ chọzi ka ndị ọkaiwu niile nyefee ka ya jiri aka ya wee kpepụta onwe ya. Ọ ga-abụzi onye ọkaiwu onwe ya ịghọtago ya nọchite anya onwe ya dịka ọ na-abụ ife a na-akpọ defense. Ọtụtụ ndị mmadụ ajụ n'anya bụ ajụ nke bụ eziokwu bụ na m abụrụ m onye ọkaiwu, mana afụ m ebe onye ọkaiwu bụ onye na-abịa ọbịa ọ na-ekwu ihe gbasara ikpe gasị pụta wee kwuo onye bife wee sị ka ọ kọwaa ya. Ma ọ bụrụ na Maazị Nnamdi Kanu jiri aka ya wee kpebe ikpe, o nwere ihe ga-eme, ọ ga-ada, ọ ga-eme ka ọ detụrụ n'ugo iwu akwadoro ya ime ya bụ ife. Maka na ọtụtụ ndị mmadụ ekwuo n'okwu gbasara ya bụ ife ahụ ọ chọrọ ime. Ụfọdụ asịgo na nke anụnwa na ọ ya ada, ụfọdụ asị na iwu anabatara ya, ụfọdụ asị nke a nke ọzọ. Achọrọ m ka ịtụrụ onwe arụ anyị gee ntị mana ife nwanne anyị nwoke anụnwa kwuru banyelu Maazị Nnamdi Kanu ịnọchite anya onwe ya n'ụlọ ikpe na ibu ịnọchite ọ nwere ọghọm dị na ya ka ọ nọ anyị uru dị na ya. Ọ dị mma ntị na ndụmọdụ Maazị Nnamdi Kanu na ọ bụrụ na ọ chọrọ ime ya ka ọ daa gbasa ozi aka ndị ọzọ n'anya
Nnamdi Kanu has debriefed his late counsel, Kanu Agabe, senior advocate of Nigeria, and has also debriefed the other senior advocates of Nigeria that worked with Chief Kanu Agabe. And his entire defense team has been debriefed by Nnamdi Kanu here. This is Nnamdi Kanu, the person that has been standing trial at the Federal High Court for some time now. Now, he has debriefed them. And his reason is that he says he wants to defend himself in person, right? So in this video, we ask and answer certain questions. What says the law in the circumstance? What says the law? Can Nnamdi Kanu defend himself in person before the High Court? Can he address the court on issues of law? Are there limitations that he may likely face on the way? Are there limitations? Okay. What's my advice to Nnamdi Kanu? We look at all of that in this short video. This is Nnamdi Kanu today at the Federal High Court in Abuja, defending himself. You know, he made it clear to the court that, he's going to defend himself when asked the question. The court even asked whether the court should appoint a lawyer for him. He said no, that he wants to defend himself, right? So we look at question number 1. Does the law allow an accused person to defend himself? The answer is yes. Section 36, sub 6, sub C, 36, sub 6, sub C of the 1999 Constitution, right, provides every person who is charged with a criminal offense shall be entitled to defend himself in person or by legal practitioners of his choice. Note, in person, right? So, Nnamdi Kanu's decision is allowed by the Constitution. The law allows, if you believe that you have the capability of defending yourself even better than your lawyers, the law allows you to do so. And that is why the decision that Nnamdi Kanu has taken today has not been turned down by the court. He's been allowed to defend himself because by Section 36, sub 6, sub C of the 1999 Constitution, every person who is charged with a criminal offense shall be entitled to defend himself in person or by legal practitioners of his choice. Now, this is Nnamdi Kanu. The next question is, what will be the procedure? We know the procedure when a lawyer is the one defending an accused person. So what's the procedure when it is the accused person that's defending himself, right? The procedure is that he will have to lead evidence in his defense and testify also in his defense. So he enters the witness box and then leads evidence in his defense, testifies. He will also be allowed to tender documents or video recording, while testifying in the court. So before now, if it was his lawyers that led him, the lawyer that would lead him will say, do you remember these documents? Do you remember this video? He will say, yes. What do you want to do with it? I want to tender it. Okay. But this one is defending himself. So he does all the tendering of the document and of the evidence, any other evidence that he wants, maybe video evidence or whatever. He does it personally because he's both his lawyer and the accused person. He's still the person here in the courtroom today. So the next question is, how about the calling of witnesses? He will be given the opportunity to call his witnesses voluntarily and to subpoena anyone he wishes to. He can call whatever number of witnesses he wants to call. Every accused person is entitled to be given every available facility to defend himself, whether in person or through the legal practitioner. Now that he has chosen to defend himself in person, all the rights and privileges accruable to an accused person will also accrue to him, even though he's defending the matter by himself. He has listed a number of witnesses from what he told the court today. He said that he intends to call Nyesom Wike. Nyesom Wike is the Minister of the Federal Capital Territory. I do not know why, right? But he knows why. He says he wants to call Governor Sanwo-Olu of Lagos State. That's the current governor of Lagos State. I do not know why. I'm trying to see the connection between Sanwo-Olu, Nyesom Wike, and the trial that he's standing in court, but he knows better. Number 3 is that he wants to call Hope Uzodimma, the governor of Imo State. He wants to call Abubakar Malami, senior advocate of Nigeria. That's the immediate past Attorney General of Nigeria. He's the person that was on the saddle when Nnamdi Kanu was extradited from Kenya back to Nigeria. Number 5, he wants to call General Toko Buratai. Toko Buratai was the, I think, chief of army staff during the time of the arrest of Nnamdi Kanu. He also wants to call Dave Umahi as one of the witnesses to be called. He wants to call Okezie Ikpeazu. Dave Umahi is the current minister of works in Nigeria. Okezie Ikpeazu is the immediate past governor of Abia State, so he wants to call him also as a witness. Number 8, General Theophilus Danjuma. General Theophilus Danjuma is retired chief of, I think, army staff. Number 9, he wants to call Ahmed Rufai Abubakar, former National Intelligence Agency boss. He also wants to call Yusuf Bichi, former DSS boss. I do not really understand why Nnamdi Kanu wants to call all of these. It looks like some of these persons will come to court and testify against him. It doesn't look like these are witnesses that will testify in his favor. These look like those that will certainly become hostile witnesses in court. But like I said, Nnamdi Kanu understands better why he wants to call all of them to the court. The question is, what if they refuse to go? What will happen? That means Nnamdi Kanu will now have to ask the court to self-subpoena, to issue and self-subpoena on these people to appear. The next question is, what if they still refuse to appear? What can Nnamdi Kanu do in the circumstance to really compel them to appear? These are the things that he will have to grapple with. Now, but what are the likely challenges that Nnamdi Kanu is going to face in defending himself in a serious criminal matter? A serious criminal matter. What are the challenges? Number 1, he will find it difficult to understand the principles of law applicable in criminal trials of this nature. There is no way he will avoid this. Nnamdi is not a lawyer. It's a serious criminal matter. And so Nnamdi is going to find it difficult to understand some principles of law applicable to criminal trials. Number 2 challenge that I have seen is that he will see himself saying too much. He will say too much. And in the process, giving too much away. So this is where a lawyer is needed, so that the lawyer knows what to say, the evidence that is important for your defense. So what is going to happen, what I can see happening, that is going to happen, is that Nnamdi Kanu will be saying too much in court, being his lawyer, in quotes. And in that process, he will be giving too much away. Some of the things he will give away will be such that might be detrimental to his case. Number 3, he will be tempted to call many witnesses. I think he said he's going to call 21 witnesses or something, and that he needs 90 days to call them. Now, in some cases, the more the witnesses, the more damaging it becomes to your case. That's why there are some cases that only 1 witness is enough, 2, enough, 3 becomes a crowd. You don't need them. So when Nnamdi is saying that he wants to call 21 witnesses and that he needs 90 days, which is 3 months, to call all of them and then have them present their cases in court, it's something that it's something I can foresee in this matter, right? It is not the number of witnesses that matters. It is the quality of evidence. So 1, 2, 3 might be sufficient. But if you feel strongly that you want to call as many as, the court is certainly going to allow him. 4, if a written address is needed and laws are to be cited, he will run into trouble here, as a non-lawyer may not be able to cross this hurdle. Final written addresses or intermittent written addresses during interlocutory applications. The court says, address me on this issue. How is Nnamdi going to be able to address the court on issues of law in written addresses? Number 5, on the side of the prosecution is a senior advocate with a retinue of other lawyers, senior lawyers also. This senior advocate that is prosecuting for the federal government, Chief Awomolo, understands law better than Nnamdi. He has been a prosecutor for many years. It might be difficult for Nnamdi to match him. That is why it would have been good for Nnamdi to have lawyers to be able to match the prosecution. It might be difficult for Nnamdi to match him because he has knowledge of law of many years standing, and for Nnamdi to now match him and then be able to defeat him in argument in court, it is one of the problems that I can foresee moving forward. 6, the tendering of evidence will be met with serious opposition. It is not going to be quite easy for him, even though the law allows him to defend himself. Yes, the law allows you to defend yourself. But something like the tendering of evidence, Nnamdi can have very important evidence he wants to tender in the court. And as he's bringing it out, objection is raised because he has not complied with the provisions of the law regarding the tendering of evidence. And this is going to impact on his case. Imagine a piece of evidence that is covered by electronic law, okay, by law governing admissibility of electronic evidence. And he brings it to just tender like that. The lawyer to the other side raises objection, says that's not the procedure for the tendering. How will Nnamdi be able to cross that hurdle? These are the hurdles that he's sure going to face. I can see him facing these hurdles in the course of the trial. Yes, the law allows him to defend himself, but the law does not exclude you from these hurdles. Okay? Now, what's my advice to Nnamdi? Nnamdi should get another set of lawyers to defend him. That's my advice. Nnamdi should get another set of lawyers. If he doesn't believe in that set of lawyers anymore, that's fine. A client can debrief a lawyer at any point. What the law says you should do is make sure you don't owe the lawyer. You pay him. Once you pay him off, that's fine. You choose another set of lawyers as much as you want. This set is not the first set. I think I had seen Michael Zuckerman in this matter before. I had seen Ejiofor in this matter before. and I've seen other persons. So this is not the first set of persons that he has debriefed. He has the right to debrief lawyers at any point in his trial. But I am saying, from experience as a lawyer, I'm a courtroom lawyer. I've done litigation for many years. And I'm saying it is too dangerous, even though the law allows you the freedom to do the defense by yourself. It is too dangerous to embark on it by yourself. So my advice is, Nnamdi Kanu should get another set of lawyers to defend him as quickly as possible. Let him not go into the trial by himself. The law allows it, but it is very dangerous. Criminal trials are delicate trials. If you miss it, you land in jail. It doesn't allow for gamble. It doesn't. There's no room for gamble. No gambling when it comes to criminal trials. And therefore, there is need for Nnamdi to understand this. So don't push further on your own. It is risky to do so. This is my advice to Nnamdi Kanu. But if he wants to defend himself by himself, as he has told the court today, the law allows him. But I have said it is too dangerous to pursue it by yourself. And I wish Nnamdi Kanu the best. I wish every party the best in this matter. And we hope to see as the events unfold and as the days go by.